Afternoon, we're back on the record here. We deliberated closed session regarding some hearings that we had this morning. So I want to say Happy New Year to everybody. Thank you all for joining and participating today. I'd like to first welcome and introduce our newest board member, Dr. David Paris here, who was appointed by Governor Jerry Brown prior to his departure. Dr. Paris certainly brings a wealth of experience, and I'm confident he's going to be a very valuable member of the team. Additionally, Dr. Dion McLean, who is unfortunately unable to join us today, was reappointed for an additional 4-year term and recently elected as vice chair of the board. This year has been off to a very busy start. First of all, Mr. Rufino and I were fortunate enough to attend the swearing-in ceremonies and functions for the new governor, Gavin Newsom. Starting off in January, Mr. Pulio and I attended the governor's budget meeting at DCA here. And January 15th, I attended Life West and presented on behalf of the board, had an opportunity to address many of the senior students. I want to thank Marcus MacArthur for putting together a spectacular presentation. That will also be used next week, coming up, by Dr. Dion McLean down at Southern California University of Health Sciences. So this is part of our ongoing outreach effort of bringing greater awareness of the board's duties, our rules and regulations governing the profession, and resources available for students and licensees. We'll continue to have future board meetings. Our next meeting is at one of the chiropractic colleges, and we plan on having additional board meetings at the various school campuses and continuing to make our efforts available and educational efforts available for all continuing ed providers in an effort to better educate all of our licensees and students about common violations. And the hopes is that with these outreach efforts, we're going to raise the standard of care, which will ultimately benefit the people of California. We also had a meeting with CCA's Executive Director, Don Benton, who's here, and President Danny Gambino to discuss future priorities and ways in which we can continue working together. Just this past week, we had a meeting with the Chiropractic College School Presidents, Dr. Ron Oberstein from Life Chiropractic College West, Dr. Bill Meeker from Palmer Chiropractic College West, and Dr. John Scringe from Southern California University of Health Sciences. And our focus was just looking at ways in which the board can continue working with the schools in regards to regulation, but additionally looking at ways where we can make the educational process much more contemporary with current day science and streamline their methodologies of teaching. We just recently also had a meeting with the medical board to discuss corporate practice of medicine, physician employment, integrative practices, and collaborate on future enforcement measures. So our enforcement team's doing a great job thus far, and we'll get an update on that shortly. But we just wanted to make sure that we have a good open line of communication, not only with the medical board, but I think with all other healthcare boards, because our similarities far outweigh our differences, and certainly there are many cases where we could assist each other in making sure that we best serve the people of California. So with that, I want to thank you all for being here and certainly encourage you all that we're here and we want to make sure we have an open line of communication with not only people in the DCA, but our licensees, our students, our school and the administration, to make sure you give us some feedback if you have any brilliant ways that we could better serve or any feedback on things that we need to be doing differently. We have materials available on the desk there. We have a phone are always being answered at the board office. Mr. Pulio and Marcus have been very, very helpful at providing their emails to people and answering questions. We have ways to follow us on social media and sign up for our email list, and that will bring you up to date on any changes that are taking place. But most importantly, we just want to make sure that we are able to interact and we have feedback from all of you and many people that are watching, so we can make sure if there's any other ways that we could better serve the people, we want to do so. So with that, we want to move on to the approval of the January 8th board minutes.
Make a motion to approve the minutes.
Second.
Any
Second that motion.
Any discussion? Call for the vote. Public comment, I'm sorry. Call for the vote. Mr. Rufino?
Dr. Azzolino?
Yes.
Frank Rufino, yes. Dr. Dan?
Yes.
Dr. Leekman?
Yes.
Dr. Paris?
Yes.
Okay, motion passes unanimously. Second is ratification of approval of license applications.
I'll make a motion to approve the license applications.
Second that motion?
Any discussion? Public comment? Please call for the vote.
Dr. Azzolino?
Yes.
Frank Rufino, yes. Dr. Dan?
Yes.
Dr. Leekman?
Yes.
Dr. Paris?
Yes.
Passed unanimously.
And now we have ratification of denied license applications, which there are none. And we have ratification of approved continuing ed providers.
I so move.
I second.
Discussion? Public comment? Call for the vote, please.
Dr. Azzolino?
Yes.
Frank Rufino, yes. Dr. Dan?
Yes.
Dr. Leekman?
Yes.
Dr. Paris?
Yes.
Unanimous.
This is going to be the most efficient board meeting we've ever had. And we have the EO, Executive Officers Report. Mr. Pulio?
The efficiency ends here.
That's why I said that.
Good afternoon, everyone. So for my report, I'll be going over admin, licensing, and enforcement. A few updates. Marcus MacArthur, the board's assistant executive officer, and I had an opportunity to visit Palmer College a couple of weeks ago. And also, while we were there, Cisco headquarters is right there in the neighborhood where Palmer is. And we were able to get a tour of their health clinic, which was very impressive. And one of the, a member of CCA, Dr. Bill Updike, he's a chiropractor for Cisco, and so he was able to get us the inside tour, and they have an integrated model there where they have various, they have an integrated model there with various health professionals, chiropractors, acupuncturists, MDs, nurses, and the services are available to their employees. So that was it was an interesting perspective, and now we're seeing a lot more through the board office that there's a lot more integrated and multidisciplinary practices, and getting to see that firsthand was helpful. And also we had a tour of Palmer College, which I've been to Palmer a couple of times but never had the full tour. So so that's my big outing for the new year. And then on to administration. We have a few changes that have happened and are happening. I'm happy to introduce our new enforcement manager, who started late last year. Her name's Kristen Walker. She's sitting here next to Marcus, and she came to us from the Architects Board, where she was an enforcement analyst, and she's hit the ground running and has quite a bit of enforcement background from her work at Architects Board. So we're very happy to have Kristen and look forward to working with her for years to come. Then on the flip side of that, we recently had some announcements. One of our longtime employees in enforcement, Lavella Matthews, is retiring. She's been with the board longer than I have. I've been here 10 years. I think she's been with the board closer to 20 years probably. She has many years of state service, and so now she's going to be retiring in a few months. And also Nakia Capizano, who's here with us today, she's moving out of the area with her family, and so she's found a job in the Bay Area and will be leaving us at the end of this month. So we're sad to see Lavella and Nakia go, but happy they're both going for positive reasons. So that's all on the admin front. Oh yeah, I'm sorry, I forgot. We have Valerie James, who's also here, hiding back there. She was our management services technician for the past few years. She's recently been promoted to a staff services analyst position in enforcement. So she's one of our newest enforcement analysts, and right now she's wearing all sorts of hats because she's still filling in with her old position and learning her new position. So thank you, Val. And while I'm doing this, we have a few staff people here in the audience, so I just want to introduce them and thank them and the staff that are back at the office for everything they do to keep us on top of our licensing and enforcement and put these meetings together. And so I've already introduced Nakia. And then we have Natalie Boyer, who's our licensee. She's a licensing and continuing education, primarily continuing education analyst. Andrea McMillan, she was an enforcement analyst. Now she's our policy analyst, been in that position for about 6 months or so now. And Tammy Pitto, who's she's a licensing analyst, and recently she's been taking on more responsibilities and been working on special projects and research projects, and been an immense help. And I think that's all as far as our staff here. So, and of course Marcus. So I just want to acknowledge and thank the staff, because they usually we don't see them at the meetings, but they make everything happen. So next I'll cover budget, and I'm going to combine two things because we have a budget update, and we're fortunate to have our budget analyst here with us, and we also have the chief of the Office of Information Services, and I'm going to have them present kind of at the same time, because we're in the process. We were for those of you who are familiar with Breeze, and there were 3 rollouts. We were in rollout 3, so we that didn't happen, and so now we've been working on identifying our business needs and looking towards getting a new system for us. And so, of course, there's cost associated with that, and so I wanted to present those at the same time because the topics may overlap. So with that, I will introduce Jason Piccioni, who's the Chief of Information Services. Huh? And Marie, I'm sorry, Marie, I forgot your last name. It's Reyes. So Marie Reyes is, and in my defense, she's only been our analyst for a few months. So we, and I'm bad with names, so I apologize for forgetting. But yeah, so they will present respectively. I don't know, maybe we'll start with OIS and with the Breeze and Business Modernization update, and then we can, that'll give information to segue into budgets. So.
Okay. Good afternoon, Chair Azzolino, Executive Officer Pulio, and board members. My name is Jason Piccioni, and I am the Chief Information Officer for your Board of Chiropractic Examiners, as well as the Department of Consumer Affairs. I'm here today to provide a brief update on your business modernization effort. This effort is paved with 3, and just to clarify, your business modernization effort is the current label for what Mr. Pulio described as the extension of the Breeze project. Not the Breeze project that ended in 2016 with the rollout of Release 2 and the Release 3 programs were de-scoped at that point, leaving us now with our current business modernization effort. This business modernization effort is paved with 3 guiding principles: transparency of government, transacting government in ways that are expected by your licensee population and the citizens of California. As an aside, these first 2 principles have been strongly affirmed by our new governor, Governor Newsom. And finally, this effort is a business project, driven by your business, for your business, an effort that bends to the priorities of your business, which I think is a critical hallmark to note. I will begin with where we have been. Your board relies and has relied on a legacy mainframe system that performs as it was intended, but lacks the modern features that all have come to expect, namely robust online presence, an interactive online application portal, credit card acceptance, easy access to public data, and mobile inspections are some of the features that may assist your board to transact government more efficiently and with ubiquitous platforms. Where are we now? Your board has been great working through the first phase of this business modernization effort, a phase we refer to as business activities. For 12 months between the summer of 17 and 18, your staff, in collaboration with DCA's Organizational Change Management team, worked to identify and document every business process performed by your board. They then took a subset of those mapped business processes and re-engineered them, looking for efficiencies with an eye for streamlining. They then boiled all of that work into a requirements document that will be used during procurement to confirm the proper platform choice. Your staff mapped, reviewed, and approved 77 as-is business processes, re-engineered 54 of those business processes, and documented 518 requirements. All business projects with a technological component in California is subject to a project approval process, a 4-stage project approval process administered by the California Department of Technology. In September 2018, your board worked collaboratively with DCA staff to draft and submit the first stage of this approval and receive stage 1 approval on November 29th, 2018. The second stage was submitted to the Department of Technology in mid-January. What's next for this business modernization effort? The 3rd and 4th stage of the project approval process will likely take us through September of this year, with an 18-month business project following that approval, putting us into the first quarter of 2021, which is in alignment with the business modernization plan submitted to the legislature in December 2017, in addition to your Board of Chiropractic Examiner's specific business modernization report. Let's talk about some of the cool features that current technology, your board's identified requirements, and stretch goals that are based on mine and your leadership's collaboration may bring to your board. As I said, a robust online presence for all transaction types, streamlined continuing education monitoring, customized and interactive reporting, and mobile inspections that may increase inspection or investigation capacity. I do not want to convey that an IT system is a magic bullet for increased capacity or efficiency. Your board and DC understands that well-conceived and maintained business processes, well-trained staff that is supported by a well-designed technology ecosystem is the magic. And I assess at this point, based on the work of your board, that we are well on our way. Thank you, and I'm happy to answer any questions you might have. Yes?
Just so I know that I understand this right. So the first and the second, the first stage was approved in November, second stage has been submitted.
Correct.
The third and the fourth stage, you said, will be approved in 2020? Is that what you said?
No, I apologize. The 3rd and the 4th stage will likely take us through September of this year.
September of this year. Okay.
2019. And the stage 3 is procurement, and stage 4 is overall project approval. And the next step is initiation of that project.
And then you said something about 2021?
Correct. After the approval of the project, then we'll initiate and execute an approximately 18-month technology project ending in the first quarter of 2021.
So your anticipating that this project will be complete and up and running in 2021? Is that what you're saying?
That's what current schedules point to, sure.
Okay.
Yes.
Okay.
And I would, just to clarify, the scope of this 18-month project will be clarified in the documents that were a part of the Stage 1 as well as the Stage 2. So I want to make sure that the completion of the project is the well-defined scope within those project documents.
And then I have one more question.
Please.
So is these Stage 3 and Stage 4, is this for our board only, or is this for all people, all boards and bureaus that weren't included in Stage 3 of Breeze?
This is your
Our
board
board.
specifically.
Okay.
One of, I spoke about the guiding principles. One of the working guidelines that we're working with is we're looking at your board individually. We're looking at we're valuing the commonalities that you have with other boards. We're valuing the differences that you may have that make you distinct from other boards. And we're taking those into consideration to make sure that the end product, whatever platform that might be, meets your requirements, serves your board specifically, and all of its uniqueness. And that was one of the big lessons learned out of previous projects. And it was also one of the findings done from a Bureau of State audit reports that came out subsequent to the Breeze project.
The reason for my questions is because we were involved with Breeze. There was money that was spent for Breeze, and I am hoping that we can be assured that since this is just dealing with our board, that our expenditures are actually going to result in a product. And if it sounds like if it's just our board dealing with it and not like this huge project like Breeze was, where we don't have a lot of control, we'll end up with a product. Am I assuming correctly?
Your assumptions are absolutely reality. It's a very fair question, valid question, one that I do field a bit. And so, yes, it's
Okay.
a fair question, and your assessment is right. There will be, through this project approval life cycle, the 4 stages of the approval process, there will be opportunities to look at requirements and similarities of other boards and bureaus that may be at the same pace of your board with similar requirements. And we will look to see if there are opportunities to share certain costs, but that grouping would not be representative of the entirety of the remaining boards and bureaus.
Okay.
So if there were grouping opportunities, it would be, again, very board serving, meaning we would share costs in areas that we could share costs that made sense. But your assessment that we're getting a product that serves BCE is the bottom line for all of our activities.
Okay, thank you.
Thank you.
Thank you for that.
I have one quick question.
So in the meantime, is there anything at all in the interim that we could roll out to facilitate things, or do we have to wait till 2021 and continue doing business as we are?
No, excellent question. There are, I'm referring to them as micro steps, just not to set expectations too high, because when we are, first let me say that your board is at the forefront of the business modernization effort. Your leadership with Mr. Pulio has highly prioritized and motivated us to move in this direction. So you are one of the first 4 in this business modernization effort. And we're looking at micro steps to take to gap now in 2021. One of the micro steps that we are looking at is potentially taking a subset of your transactions online and accepting credit card for a subset of those transactions. Utilizing current systems and utilizing current resources to do that. We want to balance the eagerness of your program, myself and others, and balance that we have a project coming up. So we don't want to do too much, but we definitely recognize that steps need to be taken between now and 2021.
Thank you. And I'm quite surprised that we're at the forefront of this, given how archaic our systems are. Are there not other boards that are taking credit cards right now?
The Breeze boards? do. So all the
Okay.
boards that were in Release 1 and 2 all take credit cards and have their transactions online. And we are working with, and other than that, there would be programs that have to date taken these micro steps that I'm talking about to take a subset of credit cards online of their transactions.
And how unique is our board in regards to our requirements? Aren't most of the things that we transact very similar across various specialties?
I think if you look at a 10,000-foot level, you have a lot of similarities. Then when you hover down, you start seeing the uniquenesses and the nooks and crannies that we want to value, both the similarities so we can achieve cost sharing and make sure that we take into consideration the uniquenesses. I think your board is very similar in ratios between similarities and uniqueness of what we're seeing, which again gives us the ability and opportunities to look for cost sharing scenarios. But our eye is on the prize to value both the sameness and the differences.
Last question here. I would hope that, and I'm assuming it's being done, if you see differences or ways that we can share in some best practices, that we're looking at that throughout this process.
Yeah, one of the things when we initiated this process was process mapping, and we worked with individuals from DCA's training and business management office to go through, and it's long, tedious. We spent I think it was the summer of 17, the whole summer just going through staff meeting with individuals from Solid and going through each of our processes and identifying each of the steps, and they documented all of that, and that's what informed was helping to inform the decisions for our next system. So that's one step in going through that. We were able to identify processes that could be streamlined, and then, of course, when we have new technology, that will make certain processes more efficient, so.
Thank you.
Jason, you mentioned a couple of those processes. Can I just get a little bit slower list of some of the top ones that, the cool features that you had mentioned? Just to make it clear, some of the cool features that you had mentioned.
Sure.
You went over it kind of quick, so I just want to write it down.
Sure.
And I want to let everyone else know.
Thank you, appreciate it. One of the things, a major focus, where high priority for us is making sure that all of your transactions can be done the way that your licensees and the citizens expect them, online, on mobile devices, easily, paid with a credit card, those types of things. The same way we transact retail business all day, every day, banking business, there should be no difference in transacting government with your board or any other board within DCA. That's our goal. So a very robust online presence that has look and feel of that same landscape that you see across the internet. That's number one. Number two is we have, and I'll utilize monitoring continuing education as a peripheral activity, but there's plenty of others. Continuing ed is an example of a peripheral activity that is quite manual right now in the sampling that your board does on an annual basis, random sampling of continuing ed compliance. What we look forward to is technologically, can we have that so you can get a higher percentage of continuing ed and monitoring without staff intervention? Can we achieve that? The answer is yes, we can. Customized and interactive reporting. One of my big pushes, as well as the current governors and past governors, is transparency in government. Let's put the public data that we house all day, every day out in the public sphere so that the folks whose data it is can use it, both in raw data set as well as interactive data set. And I apologize, I didn't bring an example of that today, but DCA has just opened its open data portal to the same effect. Put the data that we have, your board's data as well as others, out in the public sphere so people can interact, see what's going on with professional licenses under DCA. And I threw out mobile inspections as another example, of a supporting activity that we can make more efficient with technology, use of tablets, the use of mobile. When these folks are out in the field, we need to make sure that they're outfitted with tools and tool sets to get their job done efficiently and to get that information back to the mothership, your office downtown, so that they can process those items. Those are the top four that came to my mind while I was writing this. For you. There is going to be big, flashy features, and there's going to be more mundane features that help your folks in the office process the business that they need to process. And just to reiterate, these flashy features and the mundane features will be supported by your board's documented, well-designed business processes. Again, the system itself is a system, but these well-designed business processes that have been documented and redesigned over the past 12 to 15 months, will be the shining stars of this. The tech platform will support those, and the efficiencies will be gained.
Thank you.
Just two of the huge ones are the online license renewal, and even eventually we'll be able to do online license application and submitting documents electronically. And so when the hope is, and I think it will be this way, that it'll be such a convenience for licensees that we'll have a high rate of use for online renewals. People will be paying online with credit card. We won't have the manual processing and cashiering that we currently have, as well as having to deal with checks that were weren't honored by the bank, or so that would have to be returned. So it'll simplify those processes and reduce the time. And also continuing education. Ultimately, when we get that running, hopefully we will soon have a high rate of acceptance and use by licensees, and they can have all of their CE information online. They'd have their own account with the board, and also we can integrate with providers and have providers send or transmit information directly to the board. So when a licensee completes a CE course, the providers can go in and enter that information, and it'll link with the license number, and so each licensee will know in real time what they've completed, what they have yet to complete, and we would also know. So ultimately, it could eliminate the need for manual audits, because everything will be online, and we would have access to it. So I'm excited about the changes, and I know it's been a long time coming, but Office of Information Services and DCA's Solid Division and our Budget Division have been working very closely with us and really holding our hands, because this is a long, elaborate process, and dealing with other state agencies, and so I really appreciate all the help, and it's actually coming along quicker than I initially had anticipated, which is why I combined these two presentations, because as you know, we recently raised fees, and our budget, our fund was fairly well depleted, and the new fees just kicked in January, so we haven't had a chance to replenish our budget, and now we have our system moving along quickly, and a year ago, we didn't really know when we would be implementing and exactly how much it would cost. We still don't know the exact cost, but we have a better sense, and so we're looking at we need to be very frugal for a couple of years to be able to manage this, to have enough money to replenish our fund as well as pay for the new system. And so Marie will give you an overview of our fund condition and some of the high-level information that about how much money we will have in reserve and so on. So,
Jason, I have one more thing here, not to imply that you're not doing everything you can, but I'd be remiss if I didn't ask. Is there anything we could do to expedite things?
I love that offer. Not anything that comes to mind right now.
Our licensees are just hounding us constantly for how difficult it is for them to renew their licenses. And when it comes to some things like a corporate certificate, it's a $10 fee and the check and the postage and whatnot. And, our staff stuff in the envelope probably costs a lot more.
Yes, absolutely. Knowing that, working with Mr. Pulio, as far as the highest of priorities, we can take those micro steps in that direction while continuing to look towards that 21 date. But I will definitely take you up on that offer should something arise where I can utilize your assistance.
Thank you.
Thank you.
Not my personal assistance, but.
No.
He was offering money, so it just, so Marie Reyes, thank you.
Good afternoon. My name is Marie Reyes. I'm your assigned budget analyst for BCE. Thank you for having me today. Before I go over your budget, I want to provide a slight overview of how the budget process works. All BCA programs participate in incremental budgeting. What that means is that the starting point for the budget would be the prior year's Budget Act. And from that point on, any adjustments like budget change proposals, executive orders, legislative bills, adjustments are made for the expenditure authorization. I work very closely with your board, with Marcus and Mr. Pulio, to make sure that there's budget transparency. On your packet, you will find a fund condition. I just wanted to point out on the fund condition for the past year for 17-18, what you're seeing for your expenditure is not the actual expenditure. Because we haven't closed 17-18 yet. A memo was sent out back in August stating that we anticipate on making a final reconciliation sometime in March. Last update was we're right on track. Prior to the May revise, we will request an adjustment to show what it actually is. So the amount that you're showing, the 4,217 on past year, for 17-18, that's your authorization expenditure. Historically, the board does a lot of reversion. Mr. Pulio's group is very fiscally responsible, so basically, the amount that you're seeing for the fund balance of $1,285, I anticipate that to be approximately about 1.6 million. So, but once that figure is available, I will be notifying the board, Mr. Pulio and his group. We understand that we're halfway into the year. I know your frustration, same with us. But basically, I just want you to understand that fiscal is working. I mean, the contracts are executed, the POs are being paid. It's just that our system is really not in line with SEO yet. They're still in the legacy system, hence the challenge in reconciliation. I'm keeping a really close eye on the board's expenditure. I'm in constant contact with Marcus in regards to that. I think we're talking about 2-3 times a week on how we're doing with everything to make sure that we're right on board and to make sure that we'd be able to accommodate the needs for the board.
And just to clarify, since the board members don't deal with this on a regular basis, and some of it may be unfamiliar, typically, because July is the first month of the new fiscal year, and typically at the end of July, they're reconciling the last year. So they have month 13 that is where, after the dust settles, then we know exactly how much we spent in the prior year. At the end of June, we don't necessarily, everything hasn't already been posted. So, and the state recently switched to a new system, which is called FizCal, and previously it was what?
CalSTARS.
CalSTARS. So, and there've been glitches, like any major, in the entire state of California transferring to a new fiscal system, there were glitches, and I know we, board members experienced some delays in getting reimbursements, and so in the last year, and that was related to FizCal. So, so that's what she's referring to, and so we'll get our month 13 update next month.
March.
So normally we would get it at the end of July, and so that's what she's referring to. So that's, but I have to say, we're very fortunate to have Marie assigned to us, because she's monitoring that closely, since the system isn't keeping up and reporting that information. Marie's monitoring our expenditures and keeping, so we probably won't see a big difference between what she's identified and what we've actually spent. So thank you, Marie, for that.
You're welcome. Do you have any questions?
So one thing that's not figured in here is the expenditures for a new IT system. And so this, if you go all the way to the last fiscal year on here, it shows that we're going to have 0.1 months in reserve. But again, these assume that we're going to expend our full budget allotment, which in my years with the board, we never have, except I think the first year. But then, after that, we were very close the first year. But now, we monitor things very closely, and where there's budget items that we typically come in under and are able to revert money back. So that'll raise all of these projections you're seeing going forward will likely be higher. That said, we're going to have increases that we can't avoid, and so we're working with Marie, and we've identified every area where we could possibly save money and redirect that money towards the new IT system. So it'll be close for a few years. We're going to have to monitor things very closely, but I'm confident we'll be able to pay for our new system and keep moving without having to raise fees again, which is the last thing I want to do, since it was so recent that
And we're starting to monitor it right now, so, because we're
Yes.
hoping that a big portion of the reversion for 18-19 would go towards the new system. So that's the reason why I'm in constant communication with them, because we're trying to find ways to afford the new system.
How much is the new system going to cost? Or
We-
what's the,
We don't have a precise number. Do we have an idea of how much? Because we haven't gone out to bid, so we don't know what our new system will be. But I imagine they're all going to be comparable or.
So the stage 2 of the project approval cycle that I was talking about earlier has economic impact worksheets, fiscal impact worksheets, FAW, fiscal analysis worksheets, that's what they are. They've changed the name. And once that stage 2 document is approved, then those numbers would be public to share. I'll talk about general spend categories for the project, as opposed to a solid number. At this point, the platform isn't chosen, et cetera. So I could throw out a number, but it would just be a guess, and it would be less than effective for me to do that. But the big spend areas are the platform itself, whether that platform is Breeze, whether that platform is another technology that's out there. Current technology generally is cloud subscriptions. And so the big spend area would be the platform subscription on an annual basis. And then for the first 18 months, we would have a system integrator that would come in and integrate and configure that system to our business needs. Those are the two largest spends outside of temporary staff to accommodate that project.
as a board member and a chiropractor, I have no idea. You have to have some kind of idea. I don't know if this is going to be $500 or $5 million. I have no
Somewhere
idea
in
how
between.
much yeah, well, I get that. And I know you can't give us an exact number, but some kind of roundabout, because we're looking at this fund condition that's not so great. And, there has to be some idea of how much this is going to cost.
Any comparables with other boards that you could just give us a rough estimate?
The rough.
We could turn off the mics if we need to also. We're not going to hold you to it.
The broad range that I could offer would be somewhere between 1 and 3 million. Again, I'm answering because you asked. We definitely, I talked about cost-sharing opportunities. And as I even say it, 3 is high. But we'll have much better answers for you once a platform is chosen, once procurement is at least in progress, so we can understand what categories we're talking about, and those dollars will be solidified.
Yeah. And the sharing opportunities, there are other Release 3 boards that are going through this process at the same time as us, and if it turns out that our needs are substantially similar and we could likely use the same system, then we might be able to realize cost savings by going in collectively. So that's, so it most likely won't come in at the high end of that. It'll come in closer to the low end, but it's hard to say for sure.
Is there any questions I can answer for you? Good.
Well, thank you,
for
guys.
having us.
Thank you
Marie.
both.
Appreciate it.
So the next item is licensing. And the big announcement in licensing, our numbers, the numbers I report at our quarterly board meetings generally don't change much from meeting to meeting. But we did hit a significant milestone recently. In November, we fell below 13,000 licensees. I know, since I've been with the board, when I started, we were, I think, around 14,000, a little over 14. And we've been in the 13,000s for, the past 10 years or so. And recently, we went lower than that. The numbers fluctuate throughout the year, so it could go back up, but most likely it's going to stay below 13,000 and keep going down. That's been the pattern. It's been going down gradually, but it is going down. So just so the board is aware of that, and hopefully that trend will change in the near future. But we don't know. There's no way to predict whether there'll be an increase in the number of chiropractors entering the profession, in particular in California. I know there's a few states out there that haven't seen a decline in population, but the majority of other states throughout the country are seeing a decline, and most of the schools we've contacted have seen a decline in enrollment as well. Any questions related to licensing? And then finally, enforcement. So we have the chart that lists for the past 5 fiscal years. The current fiscal year is 18-19, and this is through the end of January, these numbers. So we've received 150 complaints so far this year, and looks like we'll probably, when the dust is settled at the end of this fiscal year, which ends at the end of June, we'll probably be close, maybe a little bit lower than we were in the past fiscal year. But our number of enforcement, the complaints received, and the types of violations, and so those don't vary much. Looking back, and I've gone back at previous meetings and looked historically back 10 years or more, and you see little hills and valleys, but for the most part, we remain constant in the number and types of complaints we receive. So,
Robert, it seems like there is actually a trend going down. With the exception of 14-15 to 15-16, there was a slight bump, but
yeah, and
complaints received has been on the downward.
Yeah, at the next meeting, I'll go back farther so you can see, because we do see that occasionally there'll be a spike, and then it'll go back, or there'll be a year or two where it spikes or where it goes low, but we've going back and when I've done the historical look in the past, they're always more anomalies than anything. They don't represent a pattern. It doesn't go up and keep going up or go down and keep going down. So, which is interesting given that the number of licensees is going down, that the enforcement data seems to remain fairly constant. So, and then beyond that first page in enforcement, there's more detailed charts where it gives a breakdown of the number of complaints received under specific code sections. As we know, the vast majority of complaints and discipline we take is related to unprofessional conduct, which is a wide variety of violations from gross negligence to moral turpitude, conviction of a crime, unauthorized disclosure of patient records. So there's, it goes A through X. So that's where most of our complaints and discipline fall, and then for a breakdown of where those, what we receive the most on, you can look at some of the subsequent charts. And we also have the most recent information as far as disciplinary action that's already been taken. So the accusations we filed, statements of issues, which is that's licenses or license applications that were denied for some reason, and so we don't have any those currently to report, but disciplinary actions and either surrender, probation, or revocation, citations, and so on. So you can see for this period, October 2018, this was what happened during that month. So, are there any questions related to enforcement? So, that's all I have. Thank you.
Thank you. So we are now going to have a presentation, a very dynamic presentation on the Bagley Keene Act from Mr. Swenson.
I thought he was going to walk out of the room.
Thank you, Mr. Chair, members of the board. It's that time of year again. It's the time and place for the presentation concerning the Bagley Keene Open Meeting Act. And no, you're not going to hear another popcorn presentation today. The board, as you know, has to comply with the Bagley Keene Open Meeting Act, and the board members, as part of the board member orientation, undergo extensive training in the Bagley Keene Open Meeting Act. For today's purposes, I wanted to focus on the Open Meeting Act, and the title of the presentation is A Seat at the Table, the Open in the Bagley Keene Open Meeting Act. Before we get started, I wanted to have you think about something. If you look at the organization chart on 11A, it's the organization chart for the board. And you think about what is the superior authority to the board? Well, I suppose it depends on the appointing authority. It could be someone over at the legislature, or most probably the governor. So you think of that as the superior authority to the board. But really, above that, the superior authority under our political system in California is the people of California. And so that's what I wanted to focus on today, is a seat at the table for the people of California, and why the Open Meeting Act was enacted and what the intent behind it was. So there's a handout that was distributed to all the members. It's also available at the reception table. It's a 6-page handout. And I'm going to go through that very quickly, hopefully today. If you have any questions along the way, it's probably best to ask as we're going, so we have somewhat of a dialogue. But one thing I can do is just kind of give an overview of what we're going to go over. We're going to talk about the organic and constitutional underpinnings of the Bagley Keene Open Meeting Act, the purposes of the Open Meeting Acts generally, and specifically the Bagley Keene Open Meeting Act, what Bagley Keene requires, how it's enforced, and then some discussion of what the advantages to the board members of compliance with the act is. So when we think about the purposes behind the Bagley Keene Open Meeting Act, what you're really talking about is government transparency. And historians look to, of all people, Patrick Henry as the father of government transparency. I mean, usually he's famous for the line at the Second Virginia Convention, "Give me liberty or give me death." But if you look here, there's an interesting quote where he talks about what the place of transparency is in a system of government that embraces personal liberty. And if you look at the date, it's from a quotation in the handout from 1788. That was after the Revolutionary War. And so he was looking back, and really he was towards the end of his public life. But the quote goes as follows: "The liberties of a people never were, nor ever will be, secure when the government of their rulers when the transactions of their rulers may be concealed from them." So it's the idea that there should be transparency in government, and it's an old idea that goes along with the very conception of liberty. If you think about the organic and constitutional underpinnings of this idea, you can go back to actually the Declaration of Independence. I'm not going to go through all the quotations here, but the idea here is that with our federal system, it was the people of the states that enacted the federal constitution and our system of federalism. The powers that weren't expressly provided for in the federal government were reserved for the states under the 10th Amendment. So interestingly enough, you have this conception that during the Constitutional Convention, the idea was that the states reserved their power. In turn, if you look at the California Constitution, the members of the public, the people, have reserved their power. So when our Constitution, state Constitution was formed, the people reserved their powers over the entities they were creating through things like the initiative process, the referendum process, and the recall process. So the idea is that the people did not cede their power to government when they created our state government under the Constitution. Now, specifically, there's a constitutional provision that's quoted at the bottom of page 2 of the handout that deals with the idea of why there's open meetings. And interestingly enough, this particular provision of the California Constitution was enacted after the open meeting laws went into effect. But it's still worth reciting here. The people have the right of access to information concerning the conduct of the people's business, and therefore meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. So that's enshrined in the California Constitution. So the purposes of open meeting laws generally is to require transparency in government and to promote accountability of government entities and allow the public to become aware and monitor what is going on with the agencies that have been created on their behalf. So in essence then, the open meeting laws reserve a place at the table for members of the public. There were a series of open meeting laws. The first was the California Ralph M. Brown Act, which relates to open meetings for local government. Bagley Keene was enacted later in 1967. That relates to state agencies. There's a legislative open meeting act that was enacted much later. And then there's the Gloria Romero Open Meeting Act, which relates to state universities. It's a separate open meeting act. Many other, for instance, the University of California has, their law has a code section that requires them expressly to follow Bagley Keene, so they don't have their own, if you had that question. But for whatever reason, for state universities, there's a separate one adopted. So the Open Meeting Act itself provides for the purposes for its enactment, and they're recited here at the bottom of page 3. The people do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants a right to decide what is good for the people to know and what is not good for them to know. And finally, the people insist on remaining informed so as to retain control over the instruments they have created. So those are the underpinnings and the political philosophy behind the Open Meeting Act. So the theme comes down to transparency, and the idea is to provide the people a place at the table during government decision-making processes so they can monitor what's going on. As you've learned from prior exposure through either the new member orientation or the prior presentations have been made regarding Bagley Keene, which we tend to do on an annual basis with the board. The Bagley Keene Open Meeting Act has 4 basic requirements that are laid out at the beginning of page 4. The first is to give the public notice of the place of the meetings. Second is to require that agendas be prepared and posted for all meetings, generally 10 days in advance of the meeting. The Act also requires the board to accept public testimony, so that's recognized here during our time for public comment generally, or public comment in response to a pending motion. And finally, the Open Meeting Act requires that the business of the board itself be conducted in public unless specifically authorized to be done in closed session. So the Bagley Keene Open Meeting Act does define the state bodies to which it applies, and obviously there's very specific language laid out in the middle of page 4, but it applies to any state agency. Interestingly enough, though, it also applies to committees that have actual decision-making authority. Now, our committees have the ability to recommend to the full board a decision, but they don't have independent decision-making authorities. So they're not the committees of our board are not required to post agendas under this provision, the Bagley Keene Open Meeting Act. Additionally, meetings are defined specifically for purposes of the Act, and that's at the bottom of page 4 under Government Code Section 1122.5, subdivision A. Talks about a congregation, the majority of the members, who meet at the same place and time to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the state body to which it pertains. And so anytime the majority of the members are together talking about board business, that's a board meeting. There are certain exceptions where even a majority of members can attend. Let's say a social function, that's an exception, but they can't talk about board business. One of the issues becomes if a committee has 3 or more members, then there has to be compliance with the Bagley Keene Open Meeting Act under a related section. And so therefore, committees typically are structured to have 2 members present at the meetings. One of the big themes that you're exposed to at the new member orientation is this idea of serial meetings. And interestingly enough, while the Brown Act does not have a specific provision that relates to it, the Bagley Keene does, and it's laid out at the top of page 5 here. A majority of the members of a state body shall not, outside of a meeting authorized by this chapter, in other words, the Bagley Keene Open Meeting Act, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of businesses within the subject matter jurisdiction of the body. So the idea of that is you can't circumvent the requirements of notice and open meetings by having these serial communications either in a sequence between board members or through an intermediary as in a spoken will type arrangement. And so if action is taken in violation of these requirements of the Open Meeting Act, there are enforcement provisions within the Act. First of all, it could be a civil proceeding to prevent threatened violation of the Act. There could also be a civil proceeding following a decision to determine whether action was taken in violation of the Open Meeting Act. In either of those instances, in addition to relief being granted to the petitioner, if in fact there was a violation, there could be an award of attorney fees and costs, which could be substantial. Finally, there's a criminal penalty for knowing a willful violation of the Act. I don't think there are actually any, at least reported decisions in California where anyone's been charged and convicted of that. In other states that have open meeting laws, that has happened, but I'm not aware of any cases in California. So finally, I wanted to turn to, from the board member's perspective, why would you want to suffer the inconvenience of having to comply with the Open Meeting Act? Because obviously, there's a trade-off between transparency and efficiency here. And you know, it reminds me of actually a verse that, from John that talks about this idea of why do you obey the law? Because in effect, in a way, you know, as those who love justice, we do follow the law, and so that may be sufficient cause by itself. But there are practical advantages to complying with the Open Meeting Act. First of all, the posting of the agenda in advance. It does allow board members to know in advance what is going to be considered at the meeting. It eliminates any confusion of what items will have to be addressed or not addressed at a meeting. And it prevents the members from having to consider items that are not in the agenda at the meeting. It can be if something's brought up at a meeting, we have the ability to put matters on for a future meeting on the agenda, for future agenda items. And that allows for any new issues that are brought up to be taken with regular order and to allow proper preparation. The idea of accepting public testimony at the board meetings, it actually allows members to consider the perspectives of others, and sometimes what happens is we might have some of a narrow perspective, and it's best to hear what others might have to say about a particular issue or policy that's being considered. It improves the results of the decisions and outcomes because there is that additional input, so the output's better. And finally, as a practical matter, it creates a more complete record. So if there is a challenge to a board decision, it's more easily upheld. The review of board decisions typically are given, are on an independent review basis. So a court would look at whether there's substantial evidence to support the board decision. So the more in the record, the more likely there'll be a finding of substantial evidence. So the deliberation of the body or the tribunal here, the board, would not really be called into question with this type of a review by a court. The outcome would have to just be supported by substantial evidence from which the board members could make that determination, and therefore, that's one of the most important reasons, in my view, for following the Bagley-Keene Open Meeting Act requirement that public testimony be taken at the board meeting. So with that, I'll also note that there are some resources listed on page 6. First of all, the Department of Consumer Affairs has a Bagley-Keene Open Meeting Act guide that's available as a board member resource. It's also available to the public at the web address listed on that page, which is part of the DCA publications listing. Additionally, my former colleagues at the Attorney General's office have published and updated what's entitled A Handy Guide to the Bagley-Keene Open Meeting Act. I think the latest edition is from 2004. It's available at the Attorney General's website at the address listed, and I'd have to say that it truly is a handy guide. If you have any questions about any aspect of the Bagley-Keene Open Meeting Act, it's a very handy resource. So with that, I'll conclude, unless any of the members have any questions about what we've discussed today.
Thank you, Council, for that presentation. I got a quick question regarding the different meeting laws, and I know we talked about one is for local, state, and you identify, for example, that the serial meeting, it's not covered under the Brown Act. Is there other areas where one law covers versus another?
Well, I'd have to say that the judicial interpretations of the Brown Act do recognize the prohibition against serial meetings, for instance. It's just not laid out in the Act itself. I think the reason for that is it wasn't contemplated when the Brown Act was passed, but experience as a teacher and the legislature saw fit at a point subsequently to include that in the Bagley-Keene Open Meeting Act. The Legislative Open Meeting Act is quite different than the Brown Act and Bagley-Keene, and then the one that relates to the California State Universities, I think, is largely patterned after Bagley-Keene. But although Brown Act does not have that specific provision in statute, the judicial interpretations of the Brown Act, I should say, do recognize that same prohibition, just not laid out in statute.
One last clarification question, the serial meeting phone calls. So if an individual board member calls another board member, then calls another board member, I suspect that would be considered a serial meeting. Am I correct in interpreting it that way?
That's correct. The serial meeting would occur if a board member, let's say, calls a series of other board members about a question relating to board business, or if a board member calls another board member and then that board member calls another board member, or the prohibition also applies to what's called a spoken will situation where there's some person in the middle. It doesn't necessarily have to be a board member, but some person who is the intermediary for communication. So those are all methods that at some point or another have been tried to circumvent open meeting requirements, primarily under the Brown Act. So that's why it was incorporated in the Bagley-Keene Open Meeting Act. And they do deprive the public of its seat at the table. So one way to envision it is, is there a mechanism for the public to observe or comment on the proceeding and to weigh in on the decision-making of the entity. And so these sort of serial communications deprive the public of that place at the table.
Thank you.
Great, thank you.
Thank you, Ken. So we are now going to take a 15-minute break. Heather, you ready for government affairs? We are back on the record here, and Dr. Heather Dane is going to give us an update regarding possible action on government affair and public.
I'm sorry, I'm not government affairs, I'm CE.
I'm sorry,
Oh,
that's Robert. Robert's going to give us an
Government
update on
affairs.
government affairs, please.
so, there were scheduling conflicts back when we were going to have, we made the changes to the administrative procedure manual, and then the committee was going to vote on them, but there were scheduling conflicts, and we didn't have the committee meetings. So at the next, and just during this transition with the holidays and then new officers, we haven't had any committees leading up to the committee meetings leading up to this board meeting. So so after this, we'll be scheduling the meetings, and we'll bring that back to the Government Affairs Committee. And really, that was the only item of business that the committee was needed to look at. They will have to meet in the near future to discuss legislation, so we still don't know all of the legislation that will be introduced this year. So we're watching that as bills are being introduced, and once the deadline hits, then we'll take an assessment of what legislation is out there that's of potential interest or impact, and we'll present those to the committee, so.
Dr. Dane? Licensing, continuing education?
So we had a meeting on December 17th, and one of our main focuses of that meeting was something that the full board had asked us to go back and take to committee, which was possibly making regulatory changes to the CE provider application. In our committee, we discussed the pros and the cons about separating the CE provider application from the bigger picture of the CE regulation as a whole, and our committee didn't come to an agreement. So we are back to the full board, talking about the pros and the cons of separating the CE provider application out from the bigger regulation as a whole. And the main thing that the full board is going to need to decide is if we do take that from the bigger regulation as a whole, a couple of things. One, we could have a CE provider application reg that's going through that doesn't get approved by the time the bigger regulation is already going through, and then we'll have these competing regulations for the same thing that may need to be changed. The other thing is, if the full board decides that we want to separate out the CE provider regulation, we're probably going to have to reprioritize some of the regulations that staff is working on. So that's a discussion that needs to happen with the full board, because as a committee, we couldn't agree on whether to separate it out or leave it into the regulation as a whole. Does that make sense? Anybody have any questions? Marcus or Robert, do you have any additional information?
And so given that the committee could not come to an agreement, what were the differing opinions?
So the differing opinions were, of course, one thing that the full board brought up, which is why we took it back to committee, is we don't have a lot of information about the CE providers, and Ken had let us know that even the information that the board is wanting about the CE providers may not be legal for us to get about the CE providers, such as criminal background, things like that. So our discussion at the last board meeting was that the full board still wanted more information about the CE providers, and so wanted us to promulgate a regulation for a new application. On the other hand, there are several problems with separating it out. One is staff resources and time. Like I said, we're going to need to reprioritize the regulations that we have under tab 15 if we decide we want to separate this out. The other problem is if we make changes to the CE provider application and then we finish the CE regulation, and they're going through at the same time, there are going to be changes once we do the CE regulation as a whole that are going to then have to be made to that application again, and it won't even have made it through the regulatory process. Those are the two sides.
Yeah, and one of the thing to consider, because certainly if we put a reg package together real quick and ran it through, we could potentially have a new application within less than a year. But we wouldn't be making any changes to the requirements. We would only be changing the application. So without authority to ask some of the questions that we might want to ask, which would have to be done through the regulation itself, we'd be amending the application, and we wouldn't be able to ask much more than we're already asking, because we wouldn't have the provisions in a section backing it up, saying that, the board shall require this, or, in order to be a CE provider, you have to meet these criteria. That all has to be spelled out.
In the regulation, and it's not right now.
So what is your recommendation then, Dr. Daniel?
My recommendation is that we should leave the CE provider application as a bigger part of the CE regulation. I know it's frustrating, and I know that board members want more information or having a hard time approving CE providers. However, I'm going to urge people to keep in mind, they may be approved as a CE provider, but their classes have to then be approved secondarily when they submit courses. So that's going to be my recommendation.
I got a quick procedural question, because I note that on the December 17, there were only 2 board members during that discussion, but I note that there is proposed to have a 3rd member to join that committee. So I'm just curious, I don't know if there's any value, but to refer back to committee now that you have another board member, another sets of eyes, another might make a difference, may not.
Yeah, well, I mean, certainly, because there would be more likelihood of reaching a decision, even, because if 2 people agree and 1 doesn't, then, what the 2 decide would vote.
Yeah,
Yeah, and.
rather than come to the full board before it comes to the full
Yeah,
board.
it's still, ultimately, it's going to be the full board that would make the determination, but having a new set of ears and eyes on the committee may help resolve some of the,
Send that back to the committee.
I don't know.
Or do we not?
If we do, I'll be willing to make that motion to refer this item back to committee for,
Is it still in committee?
or is it still in committee? That's
Yeah,
true.
it's still in committee, it hasn't come back to the board. And then, since this has come up, I also wanted to mention that one of the disadvantages to changing the form without supporting regulations is obviously that you could be faced with a challenge to the form as an underground regulation, because it has to be supported by regulation. And so that does weigh in favor of doing it simultaneously.
So maybe better to bring it back to the full board then.
Well, that was going to be my recommendation for some of the other items that we talked about. I mean, as you guys know, we're still wrestling with board-approved techniques, and I was going to suggest just for what Mr. Rufino mentioned, now that we have another board member on our committee, that's going to go back into committee, and we're going to discuss that more too, so we can roll in the CE application with that.
One thing we could do, if the board wants to, because it is here before the board right now, but depending on what the vote ends up being, I mean, if the board decides that they don't want to run a package just to amend the application, then we could make that decision right now, and then the committee wouldn't have to grapple with that decision. They can just focus on other things. So it depends on what the board members who are here right now want to do.
Motion to.
Yeah, so how would we word that, Ken?
To not amend, to not separate?
not separate the CE application, the provider application from the CE reg.
Yeah, I think the motion would be that the matter be referred to committee with a direction that the two provisions not be separated.
Okay.
So I think it's two-part, because it still has to be considered, the language has to be considered by committee.
So the motion would be that the full board recommends that the CE provider application be referred back to the CE committee and not separated out from the bigger regulation as a whole.
Oh, go ahead, Ken.
I think, yeah, the motion would be that the full board decides that it does not get separated and then refers it back to committee for drafting.
So refers the CE regular, or the CE, the overarching CE issue back to the committee.
And part of that CE reg is still going to include changes to the provider application.
Yeah, but it
Okay.
won't be separated
It
out.
won't be separated out. So I will make that motion.
I'll second that motion.
Any discussion? Public comment? Call for the vote.
Dr. Azzolino?
Yes.
Rufino, yes. Dr. Dan?
Yes.
Dr. Lichtman?
Yes.
Dr. Paris?
Yes.
Vote is unanimous.
Thank you very much, and I look forward to having our CE committee meetings with our new board member, Dr. Paris, and we will get back to you with more information.
So next item on the agenda here is an update discussion.
Dr. Adelina, Dr. Dane, did you want to finish the other things that were discussed in committee?
Well, we talked about, as I mentioned, we talked about the list of techniques, didn't really come to an agreement on that, so we're going to be discussing that further with input, fresh input from our new board member. We also talked, if you remember, about Oregon's provision that they are fairly nimble on being contemporary with what they can have licensees take every year if something comes up. We didn't really get a full, we didn't decide if that would be available to our board or not, so that's going to have further discussion as well. So, is that everything, Marcus?
Okay.
Oh, yeah, they had I'm so sorry. We got updated on the focus group that they had in Southern California and what stakeholders were interested in the CE committee to address in the new regulations. And there was a lot of ideas, from mandatory hours to comments on ethics and law and how many mandatory hours and who should be able to offer CE. So we got a lot of input from stakeholders as far as what they want the CE group to, the CE committee to take into consideration. So we made notes of that and we'll incorporate that into our conversations. Anything to add about the stakeholder meeting?
Just, we've, at the staff level, we've been making efforts to reach out to a variety of CE providers, the associations and the schools, of course, then also a sampling of the smaller individual licensee CE providers. And so we could see what, where they agree, where they disagree, and just have that information so that when the committee's discussing it, we can share the thoughts we've heard from from the individual we've spoken to. And so that was the impetus for that focus group, is just to get a group of people representing various factions, if you will, of the CE provider community, and just finding out where they are. We want to try to hear and address concerns at this point when we're drafting potential changes, rather than wait until we have a finished product and then find out that there's significant concerns. So that's all.
Do we tend to have those complaints, concerns coming after the fact from people that are not participating from a particular venue, group?
It's
school?
hard to say. That has happened because we've been working on continuing education for quite some time now. And at various points, word has gotten out that about something that the committee may have discussed, and sometimes we did discuss it, and sometimes we didn't. Frequently when we see that there's, we're starting to get calls and complaints and angry letters, we'll find out that misinformation was shared. Somebody heard about something we discussed and jumped to a conclusion and started telling other people the board's planning on doing this, or in some cases, the board has already done this. And even though we're just in the drafting and discussion stage, somebody will be of the impression that something's already been done and we didn't tell them about it. And so that does happen, and I'm sure it will continue to happen. And
I'm sorry, my question was, is that coming from a particular group? I mean, I know we've had some coming from the California ICA, but are you identifying any other groups that we could address very specifically,
I haven't,
proactively?
and recently there, I've been aware, emails have been forwarded to me that that did come from members of one association, and so, and the individuals, when I saw the email and who sent out the original email, that individual or a representative from the organization wasn't at the meeting, so they didn't, I don't know where they got the information that they were sharing.
Okay. Just want to stress once again that we welcome participation, and we're here for everybody here, and all the meetings are open, as are all the committee meetings are open, and so we really welcome people to participate on any level they wish to. That's when things get done, not after the fact.
Yeah, and the people, the individuals that we've been working with so far, we have only had one focus group, but the people that are engaged and are participating, that are attending meetings or calling and asking questions, we engage them because they've already shown an interest in what we're doing. And some of those individuals actually were victims of the misinformation, and at one point there's some individuals that participated in the focus group that had sent us angry letters saying, I can't believe the board's doing this, and they assumed that it was something that was a foregone conclusion, and then we were able to explain to them that no, that's not true, and you should participate, and even if you can't be at the meeting, we send out the agendas, you can see what we're going to be discussing, and if you have any questions or concerns, you can share those beforehand. So it is helpful to participate.
All right, thank you for that. So we're moving on to the update, discussion, possible action of pending rulemaking.
Good afternoon. So following recent legislation pursuant to AB 2138, I'm sorry, my name is Andrea, I'm the policy analyst. So following the recent legislation pursuant to AB 2138 and SB 1448, the board will develop regulations that will conform to new statutory mandates. Additionally, our legal counsel completed the review of the delegation of authority and the CPI regulations, and they have been returned to the board, and we're currently reviewing those regulatory packages right now. That's the update that I have for you right now. Do you have any questions?
Return to the board
So
for changes, return to the board?
yeah, there will be revisions that were recommended, and we're currently reviewing them.
There's several review stages when we're working on regs. There's several review stages when we're doing the formal reg process. The first one is the pre-review. So we put the package together and then send it over for kind of an informal review by legal in the department to let us know things that might be problematic down the line. And so we've, for those two regs, the Consumer Protection Enforcement Initiative, as well as the delegation of authority to the Assistant Executive Officer, those both have been to the department, and now the pre-review has been completed. So we need to go through and incorporate the recommended changes into the package, and then we start the formal process, and we'll send it back through, and it'll go to the department and agency and Department of Finance to get approval to initiate the formal reg process.
Sorry, I got a quick question. You mentioned pursuant to two legislative acts that
AB
mandates.
2138 and SB 1448.
So both of those, I'm not familiar. Both of those, they, can you give me a sentence or two?
Yeah. of
They
course.
ask us to do.
So, actually, they've been presented to the board, and we took, a neutral, I should say a watch position on AB 2138, and that one will limit the board's discretion to deny new applications, suspend or revoke existing licenses based on criminal convictions.
Oh, yeah, okay. Well,
And then SB 1448 was the one pertaining to requiring licensees to disclose their probationary status to all patients following the effective date of their probation.
I, thank you.
Yeah, no problem.
No,
I know I just referred to the bills, but they have been enacted, and they were chaptered last year. Any other questions?
Thank you. Okay, board committee assignments.
So,
Sheet, Rob.
yeah, I don't have the handout. We, as.
I have it, but I
Oh,
have
you have, okay. So, yeah, we sent it out to the board members a few weeks ago, because the chair, in consultation with the executive officer and the vice chair, will appoint people to committees, and with the election of a new chair, he looked at Dr. Azzolino looked at the committee assignments, and there weren't significant changes. Most of the committees stayed the same, except that we have had some changes in board members. And also with the addition of our new licensee member, Dr. Paris, we added him to two of the committees. So we have two of the committees are three-member committees now. And those are enforcement, which are Dr. Azzolino, Dr. Paris, and I believe it's Mr. Rufino on enforcement, yes. And then licensing and continuing education is Dr. Dane, Dr. McLean, and Dr. Paris has been added to that one as well. And the Government Affairs Committee, we haven't added a third person to that. We may, but as that one is right now, it's Dr. Lichtman, and I'm sorry, who's the other?
Mr.
Oh,
Rufino.
Mr. Rufino, okay. So, so we have, those are the committee assignments, and I apologize that sheet didn't make it into the package, but the committees aren't all that different. It's just, two of them have grown because we have an additional member.
I got a quick question.
Sure.
When I received this, and I don't have on the special committee to open the act and a special committee of curriculum requirements, it seems to me that we either combine these two committees. I just don't see to have two committees, two special committees. If anything, so that's one observation, but we could have two, but if we do decide to do two, my 2 cents is that if on the open of the act, I would like, that should be more members. That should be, we should have greater participation rather than limiting to two. So I was not sure, I'm not sure what it was, the thinking process to limit it to two.
These were exploratory committees. It was not to have any action. It was just simply to explore things and then to bring it to the full board and would decide.
Yeah, and so the board did vote at a prior meeting last year, the board did vote to establish the special committee for the purposes of amending the act, or to look into amending the act. So that committee is created by the board. The members of that committee, if I'm recalling, it was Dr. McLean, Mr. Ruffino, and Dr. Lichtman. So that
It's
committee.
Rufino and McLean.
Right now, it's only.
Oh, for some reason, I'm sorry, I thought Dr. Lichtman was on there. But members could be added or changed on the committee. So and if the board wants, they can have that committee meet. That committee hasn't met yet. And so we could, at this point, I think the board could vote to direct that committee to have a meeting prior to the next board meeting.
Can I provide some background?
Sure.
So we actually made up this committee at our board meeting in San Diego.
Yes.
It was on the agenda for that meeting at the request of Mr. Ruffino, but unfortunately you weren't at that meeting. So we didn't kind of have an explanation of why that got agendized, but because you wanted it agendized, we wanted to consider it and take it seriously, so we put you on the committee. So if you have some more information about why that was agendized and kind of what you wanted to accomplish with that, then maybe we could decide what we want to do with that committee.
Well, I don't have a specific goal in mind, but I've shared with both the executive officer that we hear so much from our stakeholders, and this has been an ongoing conversation. This is nothing new about whether we should open, we should not open the act. It's been, I hear it all the time since I've been serving the board. And let me premise by saying, I'm not a chiropractor, so I don't have I don't know whether we should or whether we should not. I don't have those expertise. But I do recognize, though, that there is folks on both sides that have strong feelings. And I'm saying that it would be a value for this body to assemble the greatest number of people with the greatest ideas and once and for all, to analyze and decide whether there is a benefit to open the act or not. That is really my goal. That was what I was trying to accomplish.
So I'm going to suggest that, and this is something that we don't need to take action on now, but it may be best to shift that to a 3-member committee, and we move forward with doing a meeting right away. I don't know if they need to be 2 different committees. I agree with Mr. Ruffino on that, and Dr. Dane. We split it up at that time because we were actively doing something with the educational situation with the schools. We weren't sure what we were going to be able to do. The act was something that people wanted to explore, so I'm going to suggest we just we'll have some conversations with Mr. Pulio, we'll figure it out, and then we can make those committee appointments.
Okay, yeah, because they're not necessarily related. However, we have looked at regulations, as far as the curriculum requirements in the regulations, to determine what changes could be made, and we're limited because there's provisions in the act that would need to be amended in order for us to make more substantive changes to the regulations. And so we may want to, as if the board were to consider making amendments to the act, one of the things we may want to do initially is address the curriculum, because there's a lot of obsolete provisions in the regs as well as the act, and probably would make sense and be the most efficient to amend the act and clean up everything in there that's outdated and unnecessary, and then make the corresponding changes to the regulations. So it would make sense to put those together.
And that would have to shift to a 3-member committee, correct?
Yeah, it wouldn't have to, but it probably should. And
If I may, I'm not sure if we are bound by 3 members. I mean, this is a committee that I think an ad hoc committee, so it would not be a standing committee for a special purpose, that I think the greater participation, anyone from the board, or make the whole board as part of the committee.
Well, I was thinking about that earlier. I mean, it doesn't necessarily have to be a committee. It is something that there will be a lot of different opinions about, just about, even if you don't even consider what changes might be made, just amending the act, which would require putting it on the ballot and for the voters. And so it's a big process, and just doing that is controversial. There'd be people who will have concerns and be opposed to that, and there's probably different opinions on the board itself. So you could take it directly to the board, not have it discussed at a committee, or you could have a committee discuss it for purposes of getting public comment. And because stakeholders, if we announce or advertise that we're going to be having a meeting for that purpose, I would think that there'd be a significant number of licensees who would have an interest and who would want to come and express their concerns, and then that would give the committee information to bring back to the board.
Agreed.
Do you think maybe before you actually have a committee meeting, maybe staff can prepare? Because I know when you and I talked, it helped me understand. I mean, you gave me a whole bunch of information that was very helpful to understand how complex this process is, and how much not only staff time, but political will there's got to be out there beyond just us, beyond the board. So with that said, do you think, Robert, it will be helpful for staff to prepare something like that to sort of give us an overview, kind of like some ideas before we even entertain the idea of opening or not opening, just to understand what are we talking about?
Certainly. I mean, and because there's the process, as you mentioned, it's not all that complicated, but it is there's several ways you can put something on the ballot, but the way that would make the most sense would be to have the legislature carry a bill to put a referendum on the ballot, and so we would need to approach the legislature, probably the one or both of the Business and Professions committees, and ask if they would be willing, if one of the members would be willing to carry a bill for that purpose. I think they probably would. I don't see it as being something that they would be opposed to carrying. And so it would have to make it through the legislative process. Of course, there's committees, business and professions committees, and fiscal committees that it would have to go through, and the public would have an opportunity to weigh in. If it's passed by the legislature and signed by the governor, then it would be approved to go on the ballot and for the voters. So, so I mean, I could put that in writing, that process, and then I know some of the concerns that I've heard, as far as opening the act or amending the act, and we can share those. We'll probably find out even more once we have a meeting and we have people testify and share their concerns, and hopefully there'd be arguments on both sides, and we can find out what the pros and cons might be. I don't know if that helps, but yeah, I can put
that
something.
helps, because that's in a sense that was to answer your question, Dr. Dan. That is exactly what I was hoping to do, by asking to agendize, so that we could hear all this input from all the stakeholders, from everyone, and then have a systematic way to analyze some of these arguments. Because I know this much. Yes, you could get the both professional, the legislature, you may get a legislator that's willing to carry your legislation. But if we go as a unified front, and you vetted the process, and then we go to the legislature with some message that the vast majority agrees upon, then the likelihood of succeeding are going to be greater than going to the legislature and ask them to do something, and they're going to get lobbied by multiple groups. And if it's a small minority, they may pay attention to it, they may not. But the greater, what's the word that I'm looking for? Common The more folks, we come together, the more we agree before going to the legislature, the likelihood of success will be.
Yeah, I mean, certainly we'll want to do our research, and if we're going to be submitting a proposal to the legislature, they're going to have these very questions, and so we'll want to let them know what the impact will be and who likely will support, who likely will oppose, so on. And so we'll want to be able to lay all that out, and some of that information we won't have until we start asking and conducting meetings, so. So it sounds like we do want to schedule that committee, and I will discuss with the chair the members of that committee, and at a minimum, adding one more person to that committee. And then it'll be brought back to the board at the next meeting, which is, I believe, is May 21st.
Well, hopefully we could actually have a meeting or two prior so that we have some substance.
Well, yeah, I mean, yeah, we would have, in the interim, we would have committee meetings,
Sure.
that special committee.
And how does it change, in regards to logistics, having 3 or 4 members?
Well, I
does
don't know
it-
if we can have 4 members, can we, Ken? I mean, I've never.
You referenced 4 earlier.
An advisory committee can have 4 members. It would, of course, have to comply with the notice and agenda requirements in open meeting law. So long as it's advisory, it wouldn't be a problem.
And what constitutes advisory versus?
They can make a recommendation to the board.
Sure.
I mean, potentially, if you have.
That's
four-
any committee.
Potentially, if you have 4 members on the committee, they could make a decision. If they're unanimous, then the decision might already have been made before it goes to the board. But
If you run
It's-
into a situation where there's a majority of the board members, and that's the same as a quorum at a regular board meeting. So, but if you task the special committee to review proposed changes and make recommendations to the full board, like you have, then it's advisory in nature. Then, as long as you are aware that having more than 2 is going to require actual compliance with the Open Meeting Act, which it's done anyway, even for the 2-member committees.
even the 2 or 3 member committees, we advertise, or we notice the meetings and so on.
Okay. Any other comments on this? Public comments? Okay, so.
Actually, I have one question. Is there, because right now it's Dr. McLean and Mr. Ruffino, assuming those 2 stay on the committee, is there anybody else that has an interest in this committee
Are you going to
I thought we were going
are
to
you going to
combine.
combine the 2 committees?
I certainly think there's some advantage to just combining them. I have an interest, and I would assume Dr. Dane does.
Yes.
If that requires a motion, I'll be willing to make that motion.
I don't think it should.
No, it doesn't.
This is just informative for
Okay.
Dr. Azzolino. So, okay. So, and I believe, Dr. Dane and Dr. Azzolino are on the curriculum committee.
Yes, so.
So combining the 2, and that would be 4. Okay, never mind.
Okay. Any public comments not on the agenda, for items not on the agenda? Don, you're the only one out there. Any future agenda items? Crickets? Give a moment. Nothing? Okay, well, then we will adjourn 3:13 PM. Thank you all.
Yay, we did it.